and Governance X. 1.1 Digital Personal Data Protection Act 2023. Why in the news? The President of India recently granted assent to the Digital Personal Data Protection Bill, DPDP, 2023. Background. Times in 2017, the Supreme Court recognized privacy as a fundamental right in the K.S. Puttaswamy vs. Union of India case. Times following this, the Justice Sri Krishna Committee, established by the Ministry of Electronics and Information Technology, MeitY, proposed the initial draft of the Personal Data Protection (PDP) bill in 2018. Times the government revised the draft and introduced it as the PDP Bill 2019. Bill referred to a joint committee of both the Houses of Parliament, JPC. Times, however, in 2022, the government withdrew the PDP Bill 2019 by citing the extensive changes made by the Joint Committee of Parliament to it. Times MeitY released a draft of the DPDP Bill 2022 for public consultations, which later became the DPDP Act 2023. About Digital Personal Data Protection, DPDP, Act 2023. Times DPDP Act aims to processing of digital personal data while ensuring individuals' right to protect their data and the need to process it for lawful purposes. Times it protects digital personal data, that is, the data by which a person may be identified, by providing, or the obligations of data fiduciaries, that is, persons, companies and government entities who process data, for data processing, that is, collection, storage or any other operation on personal data, or the rights and duties of data principals, that is, the person to whom the data relates, or financial penalties for breach of rights, duties, and obligations. 5 www.visionias.inf.visionias.in Copyright symbol Vision IS. Key provisions of the Act. Specifications details applicability times processing of digital personal data within India where such data is collected, or in digital form or in non-digital form and digitized subsequently. Times processing of personal data outside India if it is for offering goods or services in India. Times does not apply to, or personal data processed for any personal purpose, or personal data that is made or caused to be made publicly available by data principal to whom such personal data relates, or any other person who is under legal obligation to make such personal data publicly available. Consent times personal data may be processed only for a lawful purpose after obtaining the consent of the data principal, who shall have the right to withdraw consent at any time. Or consent will not be required for legitimate uses including the provision of benefits or services by the government, medical emergency etc. Times for a child or a person with a disability, consent will be provided by the parent or legal guardian. Data Protection Board of India, DPBI. Times provides for the establishment of DPBI by the central government. Times key functions of the board, or monitoring compliance and imposing penalties, or directing data fiduciaries to take necessary measures in event of a data breach, or hearing grievances made by affected persons. Times board members will be appointed for 2 years and will be eligible for reappointment. Times appeals against its decisions will lie with the Telecom Disputes Settlement and Appellate Tribunal, TSAT, rights and duties of data principal. Times data principal will have the right to obtain information about processing, or seek correction and erasure of personal data, or grievance redressal, or right to nominate a person to exercise rights in case of death or incapacity. Times data principals must not register a false or frivolous complaint and furnish any false particulars. Times violation of duties will be punishable with a penalty of up to 10,000 rupees. Obligations of data fiduciaries. Times data fiduciary, entity determining the purpose and means of processing, must o ensure the accuracy and completeness of data, or build reasonable security safeguards to prevent a data breach, or inform DPBI and affected persons in the event of a breach, or erase personal data as soon as the purpose has been met and retention is not necessary for legal purposes. Significant data fiduciaries, SDF. Times central government may notify any data fiduciary as SDF, based on factors such as, or volume and sensitivity of personal data processed, or risk to the rights of data principal or potential impact on the sovereignty and integrity of India or security of the state or risk to electoral democracy or public order. Times SDF will have certain additional obligations including appointing a data protection officer and an independent data auditor and undertaking impact assessment. Exemptions times rights of the data principal and obligations of data fiduciaries, except data security, will not apply in specified cases, including, or for notified agencies, in the interest of security, sovereignty, public order, etc., or for research, archiving or statistical purposes, or for startups or other notified categories of data fiduciaries, or to enforce legal rights and claims, or prevention and investigation of offences, or to perform judicial or regulatory functions, or to process in India personal data of non-residents under foreign contract. Times the central government may exempt certain activities in the interest of the security and public order. 6w. Processing of personal data of children. Times while processing the personal data of a child, data fiduciary must not undertake, or processing that is likely to cause any detrimental effect on well-being of child, and or tracking, behavioral monitoring, or targeted advertising. Cross-border transfer times bill allows the transfer of personal data outside India, except to countries restricted by the government. Penalties times Act specifies penalties for various offences such as up to 200 rupees crore for non-fulfillment of obligations for children, and 250 rupees crore for failure to take security measures to prevent data breaches. Limitations of Act. Times violate fundamental rights, exemptions for the state may lead to data collection, processing, and retention beyond what is necessary and may violate the fundamental right to privacy. Or using exemptions, a government agency may collect data about citizens to create a 360-degree profile for surveillance. Times inadequate safeguard. The transfer of personal data outside India may not ensure adequate data protection standards in the countries where the transfer of personal data is allowed. Times no compensation. The Act has removed Section 4(3) of the Information Technology (IT) Act 2000, which mandated companies to compensate users in case of mishandling their data. Times complicated approach to grievance redressal. Aggrieved individuals are required to first approach the data fiduciaries redressal mechanism. Or unresolved grievances can be escalated to the Data Protection Board, with further appeals to the TSAT. Times RTI exemption. The Act proposes that the personal information of public officials will not be disclosed under the Right to Information (RTI) Act, which could aid corrupt practices by not disclosing assets, liabilities, etc. Times clear definition. The Act provides that the data fiduciary will not undertake any processing that has a detrimental effect on the well-being of a child. However, there is no definition of detrimental effect or any guidance for determining such effect. Times no provision for some rights. The Act does not grant the right to data portability and the right to be forgotten to the data principle. Way forward. Times cross-border data governance. Mechanisms need to be developed for governing cross-border transfer of data, especially to countries not mentioned in the list provided by the notification. Times data rights. The right to data portability and the right to be forgotten should be provided, especially in cases where data collection and storage pose harm to the reputation, life, identity, etc. of a person. Times prevent misuse. Terms like sovereignty and integrity of India should be clearly defined along with a defined procedure to provide exemption. Times quantifying time duration. A specific time should be defined to delete the data once the purpose has been fulfilled or the data principal withdraws his/her consent to the processing of personal data. 7. www.visionias.inf.visionias.in Copyright symbol. 1.2 Reforming India's criminal laws. Why in the news? The government introduced 3 bills in the Lok Sabha to replace the existing criminal laws in India. More on news. Times the 3 bills include O Bharatiya Nyaya Sanhita 2023 replacing the Indian Penal Code, IPC, 1860. O Bharatiya Nagarik Suraksha Sanhita 2023 replacing the Code of Criminal Procedure, CRPC, 1973. O Bharatiya Sakshya Bill 2023 replacing the Indian Evidence Act, 1872. Times these bills have been referred to the Standing Committee. Need of these bills. Times addressing large pendency in courts. Union Law Minister stated that almost 4.7 crore cases are pending collectively in the Supreme Court, High Courts and subordinate courts. 8. Times timely justice delivery. Complex legal procedures and a lack of resources have led to many under-trialists languishing in jails, constituting around 70% of the present population. Times increasing conviction rates. The criminal justice system's inefficiencies, including inadequate forensic investigation, policing deficiencies, and the influence of powerful individuals on law enforcement, contribute to low conviction rates, around 50%. Times evolution of the criminal justice system. Societal changes and emerging challenges require an evolving and adaptable criminal justice system. Also, integrating modern technology in evidence gathering, storage, and presentation would aid in discovering various criminal dimensions. Times erasing colonial legacy. India's criminal justice system is rooted in its colonial past, which has led to a set of laws and procedures that may not be entirely relevant or suitable for the country's current socio-economic and cultural context. 1 February 2001 Bharatiya Nyaya Sanhita 2023. Bharatiya Nyaya Sanhita 2023 will repeal the Indian Penal Code, 1860, IPC, which is the principal law on criminal offences. Background. Times in 1834, the first Indian Law Commission was constituted under the chairmanship of Lord Thomas Babington Macaulay to examine the jurisdiction, power and rules of the existing courts as well as the police establishments and the laws in force in India. It produced a draft of the Indian Penal Code, IPC, in 1837, which was based on the English common law and with colonial interests in mind. The enactment of the IPC was delayed due to subsequent revisions and the 1857 revolt. It was enacted in 1860 and came into force in 1862. Times after independence, it underwent several amendments, and all these alterations and modifications made it a complicated code of law. Times the new bill aims to, strengthen law and order, focus on simplifying the legal procedure, and make existing laws relevant to the contemporary situation of the common man. Major provisions of the bill. Times sedition. The bill removes the offence of sedition, section 124 of IPC. It instead penalizes the following asterisk, exciting or attempting to excite secession, armed rebellion, or subversive activities, or encouraging feelings of separatist activities, or endangering the sovereignty or unity and integrity of India. Asterisk these offences may involve the exchange of words or signs, electronic communication, or the use of financial means. These will be punishable with imprisonment of up to 7 years or life imprisonment and a fine. Times terrorism as an offence. The bill defines terrorism as an act that intends to threaten the unity, integrity, and security of the country, to intimidate the general public or disturb public order. Terrorist acts include, using firearms, bombs, or hazardous substances, biological or chemical, to cause death, danger to life, or spread a message of fear. or destroying property or disrupting essential services, and or activities included in the treaties listed in the second schedule of the Unlawful Activities Prevention Act, 1967, such as unlawful seizure of aircraft or taking of hostages. Times organized crime as an offense. The bill defines organized crime as a continuing unlawful activity such as kidnapping, extortion, contract killing, financial scams, cybercrime, etc., carried out by individuals acting singly or jointly as members of or on behalf of a crime syndicate. 9. Potential impact. Times subjective interpretation, unclear definitions of criminal activity may lead to their improper application and affect freedom of speech and expression. For example, subversive activities might include any form of critique, or terrorist acts, which now include damage to property and provocation or intimidation. Times enhanced policing powers. Enhanced discretionary action-taking powers of police personnel may increase the scope for arbitrary police action. Times delays in existing trials. Though these bills exclude their application to pending proceedings and trials, courts are likely to be bombarded with interpretation, resulting in delays in the actual trial of the offences. 1 February 2002 Bharatiya Nagarik Suraksha Sanhita 2023. Bharatiya Nagarik Suraksha Sanhita, 2023 will repeal the Code of Criminal Procedure, 1973. The code provides for the procedure for arrest, prosecution, and bail for offences under various acts, including the Indian Penal Code, 1860. Background. Times CRPC was first enacted in 1882 by the British Parliament and has undergone several amendments, most importantly in 1898, 1923 and 1955. Times the Law Commission of India, in its 41st report, recommended a significant revision of the code, which led to the creation of CRPC 1973. Major provisions of the bill. Times detention of under trials. First-time offenders will be released on bail if they have completed detention for 1/3 of the maximum imprisonment for an offence, or if the accused has spent half of the maximum period of imprisonment during investigation or trial, he/she must be released on a personal bond. This does not apply to offences which are punishable by death and life imprisonment. Times trials in electronic mode. All trials, inquiries and proceedings can be held in electronic mode. Times medical examination of the accused. Any police officer can request for medical examination of the accused in certain cases, such as rape. Times forensic investigation. It mandates forensic investigation for offences punishable with at least 7 years of imprisonment. Or if a state does not have a forensics facility, it shall utilize such facility in another state. Times signature and finger impressions. It allows for the collection of specimen signatures, handwriting, finger impressions, and voice samples from any person, whether arrested or not. Times timelines. It prescribes timelines for various procedures such as giving judgment, informing victims of the progress of the investigation and framing of charges. Times trial in the absence of offender. It provides for the conduct of trial and pronouncement of judgment in the absence of a proclaimed offender. A proclaimed offender refers to a person who is accused of an offence punishable with imprisonment of at least 10 years or death and fails to appear at a specified time and place as specified by a court. Times stopping political waiver of punishments. The bill adds that death sentences can only be converted to life imprisonment and life imprisonment can be pardoned only within 7 years of punishment. Potential impact. Times expedited case disposal. Prescribed timelines for different judicial procedures and framing of charge sheets will help in the timely delivery of justice. Times integration of technology. The bills provide for the forensic investigation of crimes and the integration of information and communication technology, ICT, tools into the investigation and judicial process. Times improvement in rights of victims. Provision allows registration of fear in any police station irrespective of where the offence was committed. 10 www.visionyas. Times fairness in investigation. Mandatory video recording of search and seizure seeks to address fairness in police investigations. Times increase in detention period. The period during which an arrested person can be sent to police custody has been expanded. 1 February 2003 Bharatiya Sakshya Bill 2023. Bharatiya Sakshya Bill 2023 will repeal the Indian Evidence Act 1872. The Act provides rules for the admissibility of evidence in legal proceedings. Background. Times the Evidence Act was enacted in 1872 with a view to consolidate the laws relating to evidence on which the court could come to a conclusion and pronounce the judgment. Times the law of evidence, not being substantive or procedural law, falls in the category of adjective law, which defines the pleading and methodology by which the substantive or procedural laws are operationalized. Times the existing law does not address the technological advancement undergone in the country during the last few decades. Major provisions of the bill. Times electronic or digital records as evidence. It provides that electronic or digital records will have the same legal effect as paper records. Or it expands electronic records to include information stored in semiconductor memory or any communication devices, smartphones, laptops. Or this will also include records on emails, server logs, smartphones, locational evidence and voicemails. Times oral evidence. Oral evidence includes statements made before courts by witnesses in relation to a fact under inquiry. The bill adds any information given electronically to be considered as oral evidence. Times joint trials. It refers to the trial of more than one person for the same offence. In a joint trial, if a confession made by one of the accused which also affects other accused is proven, it will be treated as a confession against both. Potential impact. Times expansion in the use of electronic evidence. This can lead to a reduction in wrongful convictions and provide help in investigating cases faster. Times issues of privacy. It emerges from the seizure of electronic devices and access to the sensitive information that may be stored within them. Conclusion. The potency of reforms in the criminal justice system hinges on their alignment with its capacity to implement it effectively. The success of criminal law reforms has to take an arduous journey from its inception, formulation, implementation approach and regular oversight. 1.3 CEC and other EC, Appointment, Conditions of Service and Term of Office, Bill, 2023. Why in the news? Recently, the Union government introduced the Chief Election Commissioner and other election commissioners, Appointment, Conditions of Service and Term of Office, Bill, 2023, in Rajya Sabha. 11 www.visionews. More on news. Times it repeals the Election Commission, Conditions of Service of Election Commissioners and Transaction of Business, Act, 1991. Times bill aims to regulate the appointment, conditions of service and term of office of the Chief Election Commissioner, CEC, and other election commissioners, ECs. It also seeks to set up a procedure for the transaction of business by the Election Commission and for matters connected therewith or incidental thereto. The present process of appointment of CEC and EC. Times as per Article 324, the Election Commission consists of the CEC and such a number of other ECs as the President may decide. Times Supreme Court in Anup Banawal vs Union of India judgment declared that the President shall make appointment of CEC and the ECs on the advice of a committee consisting of the Prime Minister, or Leader of the Opposition, LOP, of the Lok Sabha, and in case no LOP is available, the Leader of the largest opposition party in the Lok Sabha in terms of numerical strength and Chief Justice of India, CJI. Times till this SC ruling, election commissioners and CECs had been appointed by the President after recommendations from the government. Key highlights of Bill. Specifications details appointment times CEC and other ECs will be appointed by President on the recommendation of a selection committee. Selection committee times it will consist of Prime Minister as chairperson, Leader of Opposition in Lok Sabha as member, and a Union Cabinet Minister is nominated by the Prime Minister as a member. Times if the LOP in Lok Sabha has not been recognized, the Leader of the single largest opposition party in Lok Sabha will assume the role. Search committee times headed by the Cabinet Secretary and comprising of 2 other members, not below the rank of Secretary to the Government of India, having knowledge and experience in matters relating to elections. Times it will prepare a panel of 5 persons for the consideration of the selection committee for appointment as CEC and other ECs. Times the selection committee may also consider any other person than those included in the panel by the search committee. Qualification of CEC and ECs. Times persons who are holding or have held a post equivalent to the rank of Secretary to the Government of India. Times such a person must have knowledge and experience in the management and conduct of elections. Term of office times CEC and other ECs shall hold office for a term of 6 years from the date on which he assumes his office or till he attains the age of 65 years, whichever is earlier. Times CEC and other ECs shall not be eligible for reappointment. Times where an EC is appointed as CEC, his term of office shall not be more than 6 years in aggregate as the EC and the CEC. Salary and allowances times salary, allowance, and service conditions of the CEC and other ECs will be the same as that of the Cabinet Secretary. Removal and resignation times under Article 324 of the Constitution, CEC can only be removed from his office in a manner similar to that of a Supreme Court judge. This is done through an order of the President, based on a motion passed by both houses of Parliament in the same session. Times motion for removal must be adopted with majority support of total membership of each house, and at least 2/3 support from members present and voting. Times an EC can only be removed from office on the recommendation of the CEC. Conduct of business times all business of the Election Commission is to be conducted unanimously. In case of difference of opinion between the CEC and the other ECs on any matter, it shall be decided through majority. 12 www.visionews. Concerns associated with Bill. Times against SC order. The proposed legislation seeks to drop the Chief Justice of India from the selection process and override the SC judgment in the Anup Banawal vs Union of India case. Times neutrality. The composition of the selection committee may lead to the dominance of the ruling party. Times eligibility criteria. Bill authorizes the selection committee to go beyond the search committee's recommendations and appoint anyone it wants as CEC-EC, thus making the entire search process redundant. Times independence of CEC-EC, bringing the Election Commission of India, ECI, under the control of the political executive is repugnant to the concept of an independent and impartial election commission. Way ahead. Times removal of EC, Article 324(5) of the Constitution should be amended to equate the removal procedures of the 2 election commissioners with that of the Chief Election Commissioner. Thus, equal constitutional protection should be given to all members of the ECI in matters of removability from office. Times multi-stakeholder approach. Steps should be taken to engage prominent jurists, CJI, independent experts, civil society members, etc., to widen the committee's scope and ensure transparency in the appointment process. Times seniority principle. The elevation of an election commissioner should be based on seniority unless the 3-member committee, for reasons to be recorded in writing, finds such commissioner unfit, as recommended by the Law Commission. Times more comprehensive consultation. Before finalizing the bill, the government should conduct comprehensive consultations with opposition parties, legal experts, and stakeholders. 1.4 Aspects of election process and reform. Why in the news? Recently, the department-related Parliamentary Standing Committee on Personnel, Public Grievances, Law and Justice tables a report on specific aspects of the election process and their reform. More about news. Times. The report analyzes the significance of elections in India and their influence on democratic governance, political representation, and societal progress. Times. It explores different facets, including voter participation and comprehensive representation through a single electoral roll, transparency and accountability of candidature, and the minimum age for contesting elections. 1 April 2001 Common Electoral Roll, CER. By consolidating the electoral rolls into a single, comprehensive database, the government could eliminate duplication and streamline the process. Provision. Times. India has two types of electoral rolls, i.e. general electoral rolls, overseen by ECI, and separate electoral rolls, prepared by SEC. Times. Election Commission of India, ECI. Under Article 324, ECI administers union and state elections like Lok Sabha, Rajya Sabha, state legislative assemblies, etc. in India. Times. State election commissions, SEC. Under Article 243K, 1, the SEC in each state has been constituted to conduct fair elections to local bodies, panchayat and municipality. Issues in the preparation of CER. Times. Absence of permanent electoral roll. Before every election, a fresh electoral roll for the local body is prepared. Unlike the assembly, local bodies do not maintain a permanent electoral roll, or this leads to duplication of efforts. 13 www.visionias. Times. Delimitation frequency. For assembly and parliamentary constituencies, delimitation happens less frequently, usually every 15 to 20 years. On the other hand, delimitation of local bodies is often done before elections, or periodic delimitation ensures fair political representation in the broader landscape. Times. Constitutional challenge. Implementing a CER, as proposed by the central government and ECI, is presently outside the scope of Article 325, which mandates the use of separate electoral rolls for elections to parliament and state legislatures. Recommendations. Times. ECI may develop a comprehensive plan that considers all the factors involved in implementing a common electoral roll before making any changes to the current regulations. Times. ECI should consider the constitutional provisions before preparing the CER and adhere to the principles of federalism. Times. ECI and the legislative department should collaborate to examine the effects of the delimitation process, especially in challenging terrains. Times. ECI and the legislative department collaborate to encourage states to utilize the election commission's electoral roll when creating their own until there is a change in constitutional and statutory provisions. Times. ECI should establish a legal provision or an alternative mechanism to ensure that non-citizens with Aadhaar are not included in CER. 1 April 2002 False declarations during filing of nomination for elections. To ensure the integrity of the democratic process, it is crucial for the government to take strict measures to deter the filing of false declarations affidavits. Provision. Times. Candidates in elections must submit an affidavit, Form 26, per the Conduct of Elections Rules, 1961, disclosing assets, liabilities, education, etc. Times. False information is a legal violation, punishable under Section 125 of the RPA. Issues. Times. False affidavits can be detrimental to the fairness of the election process as they can mislead voters and affect their choices. Recommendations. Times. Government should set up a verification process for affidavits and promptly inform the Election Commission of any false data to ensure adherence to regulations. Times. RPA 1951 needs to have a clear definition of what constitutes a false declaration affidavit. Times. Punishment under Section 125 of RPA 1951 should be increased for filing a false affidavit from 6 months to up to 2 years and a fine, depending on the severity of the offence. Or however, this penalty should only be applied in exceptional cases and not for minor errors. Times. Expediting resolution of disqualification cases, as prolonged litigation undermines the intended purpose of legal provisions. 1 April 2003 Establishing parity between minimum age of voting and contesting elections. Youthful representation in legislative bodies is crucial as they advocate for peers, address youth-centric concerns, and transform political discourse, influencing both internal and external government discussions. Provision. Times. Presently, the age for contesting elections for all Lok Sabha, Article 84, and Legislative Assembly, Article 173, is 25 years, or Rajya Sabha, Article 84, and Legislative Council, Article 173, is 30 years. 14 www. Issues. Times. Only 2.2% of Lok Sabha MPs are under the age of 30. Times. Lack of parity between the minimum age of voting, 18 years, and contesting elections, 25 years, has led to low participation by India's youth population in the political arena. Times. As per ECI, it is unrealistic to expect 18-year-olds to possess the necessary experience and maturity for these responsibilities. Recommendations. Times. Suggests reducing the minimum age requirement for candidacy in assembly elections, or reducing the minimum age requirement for candidacy in elections would give young individuals equal opportunities to engage in democracy. Times. Prioritize providing comprehensive civic education programs to equip young people with the knowledge and skills necessary for political engagement. Times. Governments, political parties, and youth organizations should work together towards enabling greater youth participation in decision-making processes. 1.5 Government of National Capital Territory of Delhi, Amendment, Act 2023. Why in the news? The Parliament passed the Government of National Capital Territory of Delhi, GNCTD, Amendment, Act 2023. More on news. Times GNCTD, Amendment, Act repeals the National Capital Territory of Delhi, Amendment, Ordinance 2023. Times the ordinance, giving the Delhi Lieutenant Governor, LG, more powers over the Delhi government, was issued after the decision of the Supreme Court in the GNCTD versus Union of India, 2023, case. The question before the court was whether the Delhi government, headed by the elected Chief Minister, or the LG, appointed by the President, would have control over services and civil servants in Delhi. The Supreme Court granted that the government of Delhi had complete command over most services in the capital, leaving out public order, land, and police, over which the central government has exclusive powers. Times in 2018, the Supreme Court ruled that the LG did not have independent decision-making powers and was bound to follow the aid and advice of the Council of Ministers. The governance model of Delhi NCT. Times classification as a union territory, UT under the States Reorganization Act of 1956, Delhi was classified as a UT, governed under Article 239 of the Constitution. It states that UTs are directly governed by the President or an administrator appointed by the President. Times special status, following the recommendations of the S. Balakrishnan Committee, the 69th Constitutional Amendment Act of 1991 conferred special status on Delhi and designated it as the National Capital Territory of Delhi, NCTD. It added Article 239R to the Constitution and made Delhi a UT with a legislature and a council of ministers. The Lieutenant Governor, LG, is designated as the administrator of Delhi, operating with the aid and advice of the Council of Ministers of Delhi. Times powers of Delhi Legislature. The Delhi Legislative Assembly has the power to legislate over subjects in the state list and concurrent list, except for police, public order, and land. The Delhi government has executive powers over the same subjects. Also, Parliament can legislate over all matters in the state and concurrent lists related to Delhi. 15 www.visionyas.inf.visionyas, Times GNCTD Act, the Government of National Capital Territory of Delhi, GNCTD, Act, 1991 lays down the framework for the functioning of the Delhi Assembly and the Delhi government. It outlines the powers of the Assembly, the discretionary powers of the LG, and the Chief Minister's duty to provide information to the LG. Challenges in the governance of Delhi. Times unclear status, Article 1, read with Article 239, provides that the UTs are to be governed solely by the President. However, Delhi's special status creates ambiguity in the administrative process. Times presence of national and international institutions, the President, the Parliament, the Supreme Court, various constitutional functionaries, foreign diplomatic missions, international agencies, etc., are located in Delhi. This requires maintaining the highest possible national standards in the administration and governance of the NCT of Delhi. Times national prestige, any decision taken in respect of Delhi also affects the entire country, having the potential of putting the national reputation, image, credibility, and prestige at stake. Times delays in decision-making, due to disagreements between LG and the elected government, there are delays in decision-making, creating inefficiencies and uncertainty in governance. Key provisions of the Act. Times National Capital Civil Services Authority, NCSA. The Act establishes the NCSA to make recommendations to the Lieutenant Governor of Delhi, LG, on certain matters related to services. Times functioning of NCSA. The central government will appoint both the Principal Home Secretary and Chief Secretary. All decisions of the authority will be based on a majority vote of the members present and voting. Times powers of the LG. Matters where the LG may act solely on his discretion are, matters outside the legislative competence of the Delhi Legislative Assembly but which have been delegated to the LG, or matters where he/she is required by law to act in his discretion or exercise any judicial or quasi-judicial functions. Times primacy to LG. The Act expands the discretionary role of the LG by giving him powers to approve the recommendations of the NCSA, or return them for reconsideration. In the case of a difference of opinion between the LG and the NCSA, the former's decision will be final. Times disposal of matters by ministers. Certain matters must be submitted to the LG by the ministers of the Delhi government, through the Chief Minister and the Chief Secretary, for his/her opinion prior to the issue of any order. These include proposals affecting the peace and tranquility of Delhi, or relations between the Delhi government and the central government, Supreme Court, or other state governments, or summoning, prorogation, and dissolution of the Legislative Assembly, and matters on which LG is to give an order in his sole discretion. Times duties of secretaries. The concerned department secretary must bring certain matters that may bring the Delhi government into controversy to the notice of the LG, the Chief Minister, and the Chief Secretary. Key issues with the Act. Times powers to central government. The Act gives the central government control over the transfer and posting of officers in Delhi. This is a departure from the Supreme Court's judgment in the Gov. of NCT of Delhi versus Union of India 2023. The meeting of NCSA can be convened without the presence of the Chief Minister as the quorum is of 2 members. Times triple chain of accountability. Conferring powers over the transfer and posting of officers to the NCSA may break the triple chain of accountability. 16 www. According to the Supreme Court, democratic government rests on a triple chain of accountability. Civil servants are accountable to ministers, ministers are accountable to legislatures, and legislatures are accountable to the electorate. The Act contradicting the first link may violate the principle of parliamentary democracy, which is a part of the basic structure doctrine. Times violates collective responsibility. Department secretaries will bring certain matters directly to the LG, the Chief Minister and the Chief Secretary without consulting the concerned minister. Times enhanced discretion of LG. As per Article 239A, the LG has to act on the aid and advice of the Council of Ministers, except when exercising functions at his/her discretion. Provisions of the Act expand the discretionary and overriding powers of LG. Times non-clarity on controversial matters. The Act provides for bringing matters that may bring GNCTD in controversy with the central government to the notice of the LG but does not define these controversial matters. Way forward. Given the system of Delhi's administration has been in flux for a long time, the following ideas can be explored for creating a more stable system. Times different models. There are varying models for governance of capital cities in other countries which can be studied for adopting a model for Delhi. These include O capital as a federal district Abuja, Brasilia, Canberra, Washington DC. There are varying degrees of federal control over these cities. O capital as city-states Berlin, Brussels, Buenos Aires. Here, the city government also carries out state functions. O capital as a city in a state Bern, Ottawa. Here, the capital is a municipality under the state government. O capital as a full-fledged state Mexico City. Times decentralization of decision-making. A two-tier metropolitan authority can be created with elected municipal councils and regional government. In Australia, the Sydney metropolitan area is divided into 31 local governments, with the state government playing a coordinating role. Times domain demarcation. The places with central government offices and their affiliates can be placed under central administration, while the rest of the NCT can be the domain of the state of Delhi. Times enforcement powers. Municipalities can be provided with enforcement powers exercised through community police officers for civil compliance, whereas Delhi police can deal with criminal issues. To know more about federalism, unique status of Delhi, kindly refer to January 2023 monthly current affairs. 1.6 No confidence motion. Why in the news? Recently, the union government faced a no confidence motion in the monsoon session of the parliament. About no confidence motion. Times no confidence motion, a legislative resolution introduced in the Lok Sabha that allows the opposition to challenge the government's majority and ability to govern. Or in a parliamentary democracy, a government can be in power only if it commands a majority in the directly elected house, implying that if a no confidence motion is passed, the government of the day will have to resign. Or the motion of no confidence can only be moved in Lok Sabha by any of its MPs. Times constitutional articles rules of business in Lok Sabha or Article 75(3) of our constitution embodies this rule by specifying that the Council of Ministers are collectively responsible to the Lok Sabha. Or Rule 198 of Rules of Procedure and Conduct of Business in Lok Sabha provides a provision regarding the motion of no confidence in Council of Ministers. Times grounds. A motion of no confidence need not set out any grounds on which it is based. Or even when grounds are mentioned in the notice and read out in the House, they do not form part of the no confidence motion. 17W. Times speeches. Unless leave is granted by the House to move the motion, no speech is permitted in support of the motion at the time of obtaining the leave of the House. Times repeat motion. After a no confidence motion has been discussed and negatived by the House, another no confidence motion cannot be moved in the same session. Implications of the no confidence motion. Times political vacuum. The passing of a no confidence motion leads to the resignation of the Council of Ministers, which may lead to a political vacuum. Times administrative challenge. The sudden removal of the political executive may lead to administrative confusion and policy uncertainty. Times parliamentary efficiency. Politically motivated no confidence motions tend to affect the optimal time utilization in Parliament. For instance, up till the current motion, a total of 456 hours have been spent discussing no confidence motions in Parliament. Times burden on exchequer. If no other party is able to prove the majority, then the citizens have to bear the expense of conducting general elections. Conclusion. The first no confidence motion was discussed in the third Lok Sabha. Since then a total of 26 no confidence motions have been discussed in Parliament. 25 of them were negatived, and one motion led to the resignation of the government in 1979. This record highlights the prevalence of opportunity to challenge the government and, at the same time, the stability of India's democratic system. 1.7 Mediation Bill, 2023. Why in the news? Both houses of parliament recently passed the Mediation Bill 2023 seeking to promote mediation as a preferred mode of alternative dispute resolution, ADR, in India. About Mediation Bill, 2023. Times defines mediation. It includes expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation or an expression of similar import. Or here, parties attempt to reach an amicable settlement of their dispute with the assistance of a third person referred to as mediator. Times voluntary pre-litigation mediation. Parties can attempt to settle civil or commercial disputes by mediation before approaching any court or certain tribunals. Times disputes not fit for mediation. Centre may amend this list. List includes, or relating to claims against minors or persons of unsound mind, or involving criminal prosecution, or affecting the rights of third parties. 18 www.visionias. Times territorial jurisdiction. Mediation to take place within the territorial jurisdiction of the court or tribunal of competent jurisdiction, unless parties agree otherwise or undertake mediation in online mode. Times timeline for conducting mediation must be completed within 120 days, which may be extended by another 60 days with the consent of the parties. Or a party may withdraw from mediation after 2 sessions. Court annexed mediation must be conducted as per the rules framed by the Supreme Court or High Courts. Times establishment of Mediation Council of India, MCI, to promote mediation and develop India as a robust center for domestic and international mediation and make regulations for registration of mediators. MCI consists of one chairperson, two full-time member with experience in mediation or ADR, one part-time member, including the law secretary and the expenditure secretary, and three ex officio members. Times defines mediation service providers as a body or organization recognized by the MCI for conducting mediation. Mediation can be done by the authority constituted under the Legal Services Authorities Act, 1987 also. Times conduct of community mediation to resolve disputes likely to affect the peace and harmony amongst residents of a locality by a panel of 3 mediators. Times enforceability. Agreements resulting from mediation will be binding and enforceable in the same manner as court judgments. Verdict can be challenged before a competent court within 90 days. Mediated settlement can be challenged on grounds of fraud, corruption, impersonation, and disputes not fit for mediation only. About alternative dispute resolution, ADR. Times ADR refers to the different ways people can resolve disputes without a trial. Other than mediation, ADR mechanisms include arbitration, procedure in which a dispute is submitted, by agreement of the parties, to one or more arbitrators who make a binding decision on the dispute. Conciliation, a non-binding procedure in which an impartial third party, the conciliator, assists the parties to a dispute in reaching a mutually satisfactory agreed settlement of the dispute. Negotiation, a non-binding procedure in which discussions between the parties are initiated without the intervention of any third party with the object of arriving at a negotiated settlement to the dispute. Times other steps to promote ADR in India. Arbitration and Conciliation Act, 1996 and Arbitration and Conciliation, Amendment, Act, 2019 for establishment of the Arbitration Council of India. Legal Services Authorities Act, 1987. New Delhi International Arbitration Centre, NDIAC, Act, 2019 for the establishment NDIAC for facilitating institutional arbitration. Commercial Courts Act, 2015 provides for the such commercial courts for adjudicating commercial disputes. Need of Mediation Bill. Times Dedicated Act. Presently, there is no comprehensive law governing the various aspects of mediation. Times reduces the burden of court. 5.02 crore cases were pending in various courts, as per Ministry of Law and Justice. Times amicable solution helps to preserve relationships amongst disputants and reduces the chance of any future disputes. Times fulfilling Singapore Convention commitment. This is also in line with India's commitment as a signatory to the United Nations Convention on International Settlement Agreements resulting from mediation. Times reduces cost of mediation. Bill introduces the concept of online mediation which can reduce the travel cost of litigants. Times less time consuming. People resolve their disputes in short period as compared to courts. Concerns related with the bill. Times online mediation. Only 55% of India have access to the internet and only 27% possess compatible devices, as per Niti Aayog report. Times prior approval. Mediation Council requires prior approval from the central government before issuing regulations related to its essential functions. This raises the conflict of interest as the government is the biggest litigant in the country. 19 www.visionias.in. Times issue of international mediation. It does not provide for the enforcement of settlement agreements resulting from international mediation conducted outside India. Times no punishment liability for breaching confidentiality. Way forward. Times include government-related disputes. Standing committee had recommended that government-related disputes be included in the bill. Times confidentiality agreement. With the start of the mediation to ring-fence any potential breach of confidentiality need to have a formal agreement. Also, there is a need for the provision of punishment liability for breaching confidentiality. Times reducing the disputes from the list. The number of disputes in the schedule should be reduced to ensure that a maximum number of disputes go through pre-litigation mediation. 1.8 Guidelines for celebrities, influencers, and virtual influencers. Why in the news? The Advertising Standards Council of India, ASI, has released the comprehensive guidelines for influencer advertising in digital media. More on the news. Times these guidelines are an extension to the Guidelines for Prevention of Misleading Advertisements and Endorsements for Misleading Advertisements, 2022. Times Department of Consumer Affairs Ministry will actively monitor and enforce these guidelines. Times influencers found to be in violation of the new guidelines could face penalties under the Consumer Protection Act, 2019. Key provisions for celebrities, influencers, and virtual influencers. Times guidelines for all. Disclosure, all material connection, such as monetary or other compensation, free products, between the advertiser and the influencer. It must be upfront and prominent so that it is not missed by an average consumer. Terms including advertisement, sponsored, collaboration, and paid promotion can be used, which must be indicated as a hashtag or headline text. Due diligence. Endorsers are encouraged to conduct a thorough review and ensure they are in a position to substantiate the claims made in the advertisement. They must use or experience a product or service before endorsement. Influencers must refrain from making false, misleading, or exaggerated claims. Guidelines for Prevention of Misleading Advertisements and Endorsements for Misleading Advertisements 2022 times Key Provisions of Guidelines, or prohibit surrogate advertisements. No surrogate advertisement, like alcohol brands advertising for sodas music, shall be made for goods or services whose advertising is prohibited or restricted. Or prohibit targeting children. Advertisements that take advantage of children's inexperience have been prohibited. Or penalties. Violations may lead to penalties under the Consumer Protection Act 2019 and other relevant provisions of the law. CCPA can impose a penalty of up to 10 rupees lakh on manufacturers, advertisers, and endorsers. For subsequent offences, a penalty can go up to 50 rupees lakh. 20 www.visionia Times for health influencer or disclosed certification. Endorsers must disclose that they are certified health fitness experts and medical practitioners. Or disclaimer, endorsers must ensure that the audience understands that their endorsements should not be seen as a substitute for professional medical advice. Times for finfluencers or registration can offer investment-related advice with subjects like banking, financial services, and insurance, BEFSI, only after registering with the Securities and Exchange Board of India, SABI. Other financial influencers must also possess appropriate credentials, such as a license from the Insurance Regulatory and Development Authority of India, IRDAI. Need of the guidelines. Times affects decision-making of consumers. People believe in celebrities, influencers, and virtual influencers. They tend to follow whatever they say or endorse. Or this may lead to negative consequences such as financial loss, health issues, etc. Or it violates the right to choose, the right to information, and the right to be safeguarded against harmful products and services. Times rising horizon of influencers. The social influencer market is expanding quickly, projected to be worth around rupees 2,800 crore by 2025. Or increased use of social media for promotional activities and influencer violations comprising almost 30% of advertisements taken up by the ASI. Or people have ample information about celebrities, for instance any cricketer, but consumers may not necessarily know much about influencers. Times clarity for celebrities and influencers. Guidelines will help celebrities and influencers to understand their social responsibility and will make them more sensitive towards their followers. Times deceptive marketing, posting an advertisement without mentioning that it is an advertisement. Or also, they claim themselves as experts in the sphere of BEFSI and health and nutrition products and services, but the reality may be different. Conclusion. Guidelines will help protect the interests of consumers. It will bring transparency to advertisements by checking misleading advertisements. It will help consumers identify promotional content and make informed decisions on products or services. 1.9 Registration of Birth and Death Amendment Act 2023. Why in the news? Recently, the Act to amend the Registration of Birth and Death Act 1969 was passed. Background. Times key features of the Registration of Births and Deaths Act of 1969 O provides for the regulation and registration of births and deaths in India. O provides for the appointment of a Registrar General of India by the central government for the implementation of this Act. O Chief Registrar, District Registrar and Registrar to be appointed in every state by the state government for the implementation of the Act in the state, district and local area, respectively. Or certain persons to report births and deaths to the registrar, like a medical officer in charge. Or provides to obtain an extract from the register related to any birth or death. Or in respect of birth or death occurring in a house, it is the duty of the head of the house, and in a hospital, the medical officer in charge is responsible for reporting. Or a birth certificate can be obtained without the name of the child. Times the registration of births and deaths falls under the concurrent list. Times as of 2019, the national level of registration of births was 93% and death registration was at 92%. Times this act had not been amended since its inception, therefore new amendment is brought to O to keep pace with societal change and technological advancements and to make act more citizen-friendly. O for efficient and transparent delivery of public services and social benefits. Key features of the Birth and Death Amendment Act 2023. Times database of births and deaths. It adds that the Registrar General of India will maintain a national database of registered births and deaths. O chief registrars and registrars will be obligated to share data of registered births and deaths to the national database. Or the chief registrar shall maintain a similar database at the state level. Times electronic certificates. Provide digital registration and electronic delivery of certificates of births and deaths. Times linking with Aadhaar. To collect Aadhaar numbers of parents and informants in case of birth registration. Times connecting database. It states that the national database may be made available to other authorities preparing or maintaining other databases like population registers, electoral rolls, ration cards, etc. Times use of birth certificate. The information will be used for purposes including admission to an educational institution, preparation of voter lists, appointment to a government post, etc. Times appeal process. Any person aggrieved by any action or order of the registrar or district registrar may appeal to the district registrar or chief registrar, respectively, within 30 days. Issues with the Act. Times against fundamental right or denying admission to school without a birth certificate may violate the fundamental right to education under Article 21A. Or linkage across databases does not require consent from the person whose data is being linked, which is against the right to privacy. Times sole conclusive proof of age. The Act does not provide alternative proof if a person does not have a birth certificate. Times surveillance state, centralizing the database may lead to mass surveillance. Conclusion: the Act, in its implementation, will help with e-governance. Although the Act defined a database, organized collection of data, generally stored and accessed in electronic form from a computer network, the government could bring robust privacy and surveillance laws. 1.10 News in Shorts. 1 October 2001 Press and Registration of Periodicals, PRP, Bill, 2023. Times Bill, introduced in Rajya Sabha, seeks to replace the Press and Registration of Books, PRB, Act, 1867 which governs the registration of print and publishing industry in the country. Times key highlights: the central government may appoint a Press Registrar General of India, PRG, and empowers PGI to suspend, cancel certificate of registration, or restricts persons convicted of offences involving terrorist or unlawful activities, to bring out periodicals. 22 www. Decriminalization of various offences as mentioned under the PRB Act 1867, e.g., improper declaration of offences. Provides for an appellate board, Press and Registration Appellate Board, headed by the Chairman, Press Council of India to hear an appeal against refusal of grant of registration, imposition of penalty or suspension, cancellation of registration by PRG. Books taken out of the purview of the PRP Bill, which were earlier subject to PRB Act 1867, books as a subject are administered by Ministry of Education. Times significance of the bill. Simplifies registration process of periodicals and brings transparency in governance of press and periodicals. Upholding media freedom. Improves ease of doing business, particularly for small and medium publishers. About PRB Act 1867. Times enacted during the Viceroyalty of Lord John Lawrence. Times the 1867 Act helped governments control the press, regulate book publishing, and inadvertently curbed the freedom of speech and expression. 1 October 2002 Advocates, Amendment, Bill, 2023. Times the bill, passed by Rajya Sabha, seeks to make the act of tout punishable and repeal certain provisions of Legal Practitioners Act 1879 which have become obsolete. Times provisions. Bill provides that every High Court and District Judge can frame and publish lists of touts. Such persons named in the list of touts will be excluded from entering the court premises. Tout refers to a person who either proposes to procure or procures the employment of a legal practitioner in return of any payment. 23 www.visionias. 2 International relations. 2.1 India agrees.